Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast. That is, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot here with Kim Strassel and Kyle Peterson talking about another momentous Supreme Court term, and it's fascinating. In many ways, I think by far and away the most interesting branch of the U.S. government now and what it is doing. Congress is mostly in gridlock, and the executive branch is pushing the law in all kinds of directions through regulation, certainly is activist in that sense. And the Supreme Court's pushing back often, as it did on the student loan case. And let's listen to President Biden react to that.
What I did, I thought was appropriate and was able to be done and would get done. I didn't give bars false hope, but the Republicans snatched away the hope that they were given, and it's real hope. Thank you.
Mr. President, will you cancel
your authority? Did you overstep your authority?
I think the court misinterpreted the Constitution.
Kyle, the court misinterpreted the Constitution. Now, obviously, the president's going to want to say that, but I think what the president misinterpreted is his authority under the Constitution to rewrite statutes without the clear and express authority of the Congress. And this is one of the themes that is emerging in this court and is reining in executive overreach and putting new guidelines, new guardrails for the administrative state when they interpret regulations. I think it's really very significant. Of course, the most significant precedent, West Virginia v. EPA from the last term, which established really fortified what had been an emerging doctrine and is now called the major questions doctrine, which says to executive branch regulators that if you're going to rewrite statutes or interpret statutes in a way that have profound economic and social implications, you have to have clear authority from Congress.
Right. And what is so striking about Biden's defense of the student loan move is that even Democrats had previously acknowledged that the president did not have unilateral authority to forgive student loans like this. And then as soon as he decided it was politically convenient to do that, he decided he was going to do it anyway. And so I find his attempt to pretend that this was not a real constitutional issue pretty politically depressing, I guess. I don't know how many people on his side of the aisle will buy that. But as far as the major questions doctrine goes, I do think this is a significant development, and you're probably going to be seeing a lot more of it in coming administrations and maybe even Republican administrations if there are Republican presidents who try to push the boundary. But I would point to a concurrence, I believe it is, by Justice Amy Coney Barrett that explains this well. And she says, consider a parent who hires a babysitter to watch her young children over the weekend. As she walks out the door, the parent hands the babysitter her credit card and says, make sure the kids have fun. And she goes on and says, in context, that means you can go and get some ice cream or something. That doesn't mean that the babysitter can take the kids on a 4-day road trip to an amusement park. And so the point she's making there, and the point the major questions doctrine is making, is that textualism is not devoid of context. You have to think about, what is this law saying? And what are the limits on the authority that it's granting the president? Because if you take it literally, it can go much farther than I think representative government is supposed to allow.
A couple of other themes, Kim, that I see emerging from the court in the last couple of years. One is there is an effort by the justices, now that they have a majority here, the conservative justices, to clean up what have been decades of muddled law and rulings. I think the Clean Water Act, the Sackett v. EPA case that you mentioned is a great illustration of that. You had this ambiguous opinion by Justice Kennedy, which probably had given the regulators more leeway than they should have. The court kind of cleaned that up. Also, the racial preferences case, 45 years of law on both sides of the issue of racial preferences, cleaned up with that in terms of admissions to college. We'll see what the implications of that are for private employers, but I think there will be some implications. Another theme is buttressing the First Amendment, both on free speech and on religious liberty grounds. You mentioned the 303 Creative case, very significant one. And then, of course, there's the filling in some of the meaning of the Heller decision that made gun rights an individual right, confirmed that as part of the Second Amendment. And they filled that in with the Bruin decision. And they've taken another case for next year, which will, I think, do more of that. Any other themes you see emerging?
I think you touched on most of them. I think it is worthwhile looking at what they're going to be doing the next term, because it really does suggest that those themes that you mentioned are ones that this court is particularly interested in continuing to build up and make more clear. So as you said, there is going to be a Second Amendment case next year, which deals with the question on whether or not it is constitutional to have this federal ban against gun buying put against those who are subject to domestic violence restraining orders. There's going to be a flood of executive power and administrative law cases. As we were just talking about this question of the major questions doctrine, there's going to be a great one that potentially tees up this question of Chevron deference, whether or not courts are obliged to give deference to bureaucrats. That's an interesting case that has to do with herring fishermen in New Jersey and whether or not they have to have monitors on their boat. There's an Americans with Disabilities Act case coming up, talking about the limits of that law in terms of what it requires of companies and notification. There's a great SEC case coming up as to whether or not these internal tribunals, which essentially act as prosecutor, judge, and jury within the SEC, if those are in fact allowed under the law. There's also one that has to do with the funding and appropriations for the Consumer Financial Protection Board. So there's going to be more of these themes coming along. And I think there are a few religious freedom and free speech cases mixed in there as well, too. And this court seems very focused, I would just like to say, on some of those fundamental amendments to the Constitution, protections in the Bill of Rights, and making sure that they are beefing them up, making them even more robust, which I think is just so important in this day and age when you see these sustained assaults on many of them from political groups, in particular issues of speech and religion.
All right. Of course, all of this has political ramifications. So let's listen to Donald Trump on the weekend take a victory lap on the court.
You know, many presidents never get the opportunity to appoint a Supreme Court justice. I had 3. They are going. They are not happy about that. And maybe we'll get 3 or 4 more. Can you imagine? Let's get 7. Let's have 7 or 8 or maybe even 9. And yesterday, as an example, they ruled, such a big ruling, to set our country back on a merit-based system of education.
Let's get 7 or 8 or maybe even 9, Kyle. Of course, one of the reasons he won't get, if he has a second term, he won't get many, if any, nominees. I suppose he could replace Samuel Alito or Clarence Thomas if one of them decide to retire there in their mid-70s. But he won't get a chance to replace Ketanji Brown Jackson because he lost the election in 2020, and that meant that Stephen Breyer would be replaced by Joe Biden. But I think you have to give Donald Trump some credit for the 3 appointments that did occur on his watch, but not total credit because he had to did commit and probably had to win the election to a list of potential nominees in 2015 that were created by the Federalist Society and a Heritage Foundation, Leonard Leo in particular. And he did that and he made the nominations off the list. This was something I don't think that he had established that he would be credible on the court because he didn't have a reputation as a conservative. And then Mitch McConnell, of course, Senate Majority Leader at the time, made sure that those nominees got through the Senate. Of course, Donald Trump doesn't want to admit that Mitch McConnell had any role in that because he hates McConnell now because McConnell has criticized him for January 6th. But my view, Kyle, is that this transformed court is a victory for the conservative establishment, if you will, much maligned by populists on the right, but they spent decades in the wilderness trying to put together the movement to be able to transform the court. And the Federalist Society in particular, creating chapters in law schools, developing young conservative judges or young students who could, if they felt, believed, and were interested in the originalist view of the law, could find like-minded people, could find mentors in some of the faculty, even if they were few and far between. And then you created a network that moved up through clerkships and ultimately to judgeships and then the Supreme Court.
I wouldn't leave out, too, Mitch McConnell's choice to not hold confirmation hearings for President Obama's nominee, Merrick Garland, which eventually led to President Trump replacing the late Justice Scalia, Antonin Scalia, with Neil Gorsuch, and also might have affected enough votes to potentially help put Trump over the line and into the Oval Office.
I agree. I don't think he would have won without that.
The Republican and conservative legal movement establishment is what has led to this court, and not even just drawing up those lists, but inculcating the kind of legal culture in which people like Neil Gorsuch and Amy Coney Barrett come up through law school and get in clerkships and get on the bench in the first place. I do think it's notable that some of President Trump's Republican rivals in 2024 are sort of nudging some attacks on this. So you heard Florida Governor Ron DeSantis the other day say that he would do better than President Trump's picks, and that none of the three justices that President Trump appointed are at the same level as Justices Clarence Thomas and Justice Samuel Alito, and he would do better. And I'm just not sure. I get that there are some of the decisions that Neil Gorsuch has gone wonky on, particularly that are annoy conservatives, but I don't know what conservative voters that line from Ron DeSantis is, who those people are going to convince. I think that conservatives and Republicans, by and large, are pretty happy with the court, the way we end this term now, with the end of racial preferences in college admissions and Roe v. Wade last term.
Well, I've actually had conversations with Governor DeSantis about the court and legal issues. I have to say he is remarkably conversant about them. I mean, he's really good. He can cite dissents. He can quote them. He can quote some of the opinions. And he's a big fan of Clarence Thomas and Samuel Alito. But I agree, as a political matter, I don't know how much voters are going to appreciate the distinction between those two justices and, say, Neil Gorsuch or Brett Kavanaugh. Kim, last word from you.
Well, I'd like to also just talk about this in terms of the politics of the Senate. It's something I think that the Republican caucus did very poorly in the last election, and that they again now have an opportunity as they head into the 2024 election to talk about this Supreme Court and the victories that have come out of it, and to warn voters about what will happen if Chuck Schumer were to obtain his aim of getting enough senators that they would get rid of the legislative filibuster, and then they could potentially make changes to the Supreme Court, its size, or other types of, quote, reforms. They're not reforms. It's designed to dilute what is currently this court. But, this ought to be a very motivating factor for a lot of voters out there. And I was really disappointed to see how few Republican candidates in the 2022 midterms talked about this issue and the risks there and the importance of a Republican majority in the Senate to keep that from happening. We'll see if they get the message and are any better about it this time around.
Well, and the stakes are high in 2024, because if Joe Biden is reelected or the Democrats win, then with the two older justices, the oldest justices now are Clarence Thomas and Samuel Alito. And, the actuarial tables, they're only in the mid-70s, so that, they'll probably live a fair amount of time, but you never know.
Look at Scalia.
Yeah, sure. Justice Scalia, nobody expected him to die at his age. So what happens is very significant in 2024 for the future of the Supreme Court. And there's maybe a complacency among some Republicans that, hey, now that we have the majority, it'll last forever. No way. And I know, Kyle, you believed in this for a long time as well, that stakes are high. All right. I want to thank everybody for listening. Thank you to both of you. I want to wish you all a very happy 4th of July. We're going to take a day off on the 4th to be with our families, and we hope you do the same, and to celebrate these great United States of America. So we'll catch you on Wednesday. Thanks for listening.